I'll be a bit more informal in my church mates because I know them for some time. Okay, so let's go into wills. First is we try to define what a will is. Can anybody tell me what a will is? When you talk about will, what comes to your mind? Piece of paper, okay, piece of paper. What else?
Legal document.
A legal document, okay. Any other?
Your wishes.
Wishes, good, okay. Anything else? You didn't talk about the most important, your property.
Yeah. Assets and property. Assets.
What is going to happen to my property? Okay, so let's go. Okay, a will is a legal document. Why do we say it's a legal document? A legal document means that when the time comes and you want your wishes to be carried out, if there's any dispute, the court takes over and the court will enforce it. In order to enforce it, it has to be legal. That means it has to meet certain requirements that the law wants. Alright, so it's a legal document. Specifies how a person's assets, okay, your money, your property, etc. These days, when somebody comes to us and says we want to do a will, in terms of property, we always ask them a few things. Number one, do you have any landed property? Do you have any HDB flat? Those are properties. Number two, do you have cash in the bank? And then, do you have shares? Do you own a ship, a boat, a yacht? Do you have a country club membership? These are all your property. Do you have a car in your name? These are all property. Okay? So, property should be distributed after their death. It allows the person known as the testator. So if you write a will, you are known as the testator. Okay? To name beneficiaries. The people that you are giving your assets to, they are your beneficiaries. Appoint an executor. Somebody has to carry out your wishes, and that person is called the executor. So you have to appoint an executor to carry out the instructions and appoint a guardian for any minor children. For those who have minor children means in our law below 21 years old, you may want to appoint a guardian. Most of the time, your probably other spouse is still living, so probably you don't need a guardian. Okay? In some circumstances, you may feel that you want to appoint a guardian, you can do that in your will. Okay? Now, I got to look at the time because I got a lot of things to say, so. Okay. For many who are believers, okay, Christians, and I have done many wills with them, and one thing I noticed is that it's quite common where they would say, my beneficiaries are, and this and this and this, they're all their children, nieces, nephews, whatever, and this is how I would give it to them. And then something struck me that there is sometimes a bit of an anomaly. If you ask them, how do you look at your property and your assets? They would say that I'm a steward. You know, I look at this, I'm a steward of God, so I got to handle this properly because I'm answerable to God. That's good. But if you call yourself a steward, that means you have a principle. Somebody you're responsible to, somebody you're accountable to. Then if that is the case, when it comes to deciding what happens to my assets, sometimes I wonder, have you checked with your principal, the guy that you're accountable to? What do I do with all these things that I still have got left? Is it that you want me to give it all to my children? You know? Or sometimes we should actually take it that I'm not the steward. These things God has given to me, and I use it the way that I want. And at the end of my life, I decide who I give it to. So it's okay, you know, either stand that you take is perfectly fine, yeah? But if you look at yourself as a steward, remember then there's a principle you would check with. What do I do with it? Yeah. Okay, so that's something that I want to talk to my church members, all right? So, okay, let's move on. So what is a will? Now, what happens if you don't have a will? It's quite common that I have clients come in to say, I want to make a will. Why? Because if I don't have a will, everything goes to the government. Who thinks this is true? No, none of you. Well, you're right and you're wrong. Okay? Now, what happens if you don't have a rule? We have got a set of rules that determine if a person hasn't got a will, what will happen to his property. So rule number 1. Without a will, the deceased estate is distributed according to the law. Okay, so now we go, rule number 1. Come right in, take a seat. You're just in time to know what happens if you don't have a will. So number 1, if an intestate dies, now I say that you're a testator if you write a will. If you don't have a will, you're called an intestate. You got no will, okay? If an intestate dies, leaving a surviving spouse, no issue and no parent, the spouse should be entitled to the whole of the estate. So if you've got a wife or a husband, no children, no parents, spouse take all. Okay, that's how it works. You will notice that there is the word issue. Issue used in the context of when there is no will has got a very special meaning. Issue means that your children, if your children did not exist at that time, but they have children of their own that exist, they will step into the shoe, okay, of the children who have passed on. So that's what, in terms of intestacy, when there is no will, issue is important. All right. So for example, you are married, you have a spouse, you have children, and these days everybody lives very, very long. You live to like 90 years old or something. Your children, for some reason, would have passed on, but they have children of their own. Their children will step into their shoes to become issue. So if you have your wife, your children have passed on, no parents, and you say, I take everything. No, you don't take everything. Your children have got children. Those children step in their shoes. So now you have to share with them. Okay? So let's come to rule number 2. If an intestate dies, leaving a surviving spouse and issue, the spouse take half, the issue take half. And if there are more than one issues, equally distributed of that half. Okay? Rule number 3. Subject to the rights of the surviving spouse, if any, the estate, both to the undistributed portion and the reversionary interest of an estate who leaves issue, shall be distributed by equal portions per stirpis, to and amongst the children of the person dying intestate, and such persons as legally represent those children in case of those children who have passed on, which is exactly what I tell you. If there is spouse, there are issues. Issues take half, spouse take half. If issues pass on, they have got children of their own, the children step into their shoe, they will take. Per stirpis means equal shares. Okay, these are some legal terms. You will notice there that there is a word called reversionary interest. Reversionary interest. What does that mean? It means that, for example, you do a will, and you say that I'd like to give some part of my property to one particular child, and you name that child by name. And then that child, for some reason, passed on. So now we look at your will, you have something that is given to this person, but this person is not around. So that part of it goes into what we call reversionary interest. That means balance of things that you have not provided for in terms of a beneficiary. Okay, what happens to that? Maybe I'll tell you that later on. And also, by the way, keep the questions that you have. I have Q&A. You can ask all the questions that you want. Okay, this is probably the only time you can speak to a lawyer and answer the questions without paying money. So rule 4. If an intestate dies leaving surviving spouse, no issue, but a parent or parents. Spouse, no children, parents. Spouse take half, parents take half. Okay? If there are more than one parent, then of course you share equally. No descendants, the parent or parents of the intestate shall take the estate in equal portions. That means you have got no children. Okay, no children, you got no spouse. So these days is quite common. You live a single life. You are single all your life. Then you pass on. No spouse, no children. Then what happens? Your parents will take. Okay. My sister, my eldest sister, she passed on about 15 years ago. She is single. She has got a boyfriend, very close to her, a nice partner that we all know, keeps her company and so on. But they are not married. And she, I don't know if it's common with you girls, cannot get along with my mother. They will, it's like if you ask her, do you have anything to do with my mother? No, nothing. And I know that if she were to pass on, she would not want to give anything to my mom. And then she had pancreatic cancer. So I went to visit her, and then she said, Kim Lark, help me to do my will. I said, sure, when you're ready, we do your will. She doesn't want treatment. She knows she's going to pass on. She goes home. She wants to kind of like prepare herself, get her things in order, and then she would go. And I'm sure in that planning, somewhere along the line is do a will. And the doctor says maybe you'll go within a month, maybe 3 weeks or something. So she kind of planned, 3 weeks, I'm going to go, and things like that. But sometimes we can do the planning, things don't happen the way you want. After the second week, she got a stroke. Once she got a stroke, what we would say you don't have now the capacity to do a will, okay? That's called mental capacity. So that's it, no will. So no will, no children, no spouse, who gets it? Who gets it? Her property. The mother. The one that she will not give anything to takes everything, okay? My brother comes to me, hey, can we have the property? I said, no, you don't. The mother takes everything. So that is how things go. Okay, so rule number 6. Of course, my sister did ask me what happens if I don't have a will, so I cannot explain all this to her. Rule number 6, okay. So no surviving spouse, no children, no parents, now brothers, sisters. So actually my brothers and sisters rank after my mother, okay? Rule number 7. No surviving spouse, no children, no parents, no brothers, sisters. Grandparents will take. So all of you who live a long life, remember your grandparents. Check first, okay, whether you're entitled to anything. Grandparents may take, okay? Okay, so next, rule 8. No spouse, no descendants, no parents, no brothers, sisters, no grandparents. Then aunts and aunties. Now you come in, okay, aunts and aunties. So, okay, it's good to be aunts and aunties. Make sure you keep your links with the family, okay? 9. In default of everything at the top, government takes, okay? So, to say government doesn't take is not true. Government takes, but government is right at the bottom. Then government takes, okay? So, let's go on. Now that you know what happens without a will, if you're happy without a will, you know where it goes to, then you don't need a will. You can now leave and enjoy your lunch or your breakfast. But if you still want to do a will, let's go on. So what do you need in a will? Number 1, like I said, mental capacity. If you don't have mental capacity, you cannot make a will. Yeah. So sometimes I have clients, you see, what is the push for you to make a will? In the old days, it is when you get very old. Nowadays, you do wills and you see young people coming. Why? Because they travel all the time now. Husband, wife travel. And then they think, I got young children, what happened? So nowadays, people do will because they travel together. Okay? then you're worried, so you do will. In the old days, only elderly people come and do will. But when that happens, sometimes you may not have the capacity. You know, I've got clients just about maybe 3 weeks ago who said that I've got a bedridden mom. She cannot talk, and can you come and do a will for her? Then the question we ask is she able to communicate? Is she lucid? Okay. Sometimes you can have dementia. Even dementia, there are lucid moments. And most important is for the doctor not to certify that this person has got incapacity, mental incapacity. If the doctor certifies that, that's it, we don't do anything. But if the doctor doesn't certify that, but you tell us that, you know, my mother has got dementia, and then we'll ask, is she lucid at times? If the answer is yes, can do will. Sometimes you have a stroke, no mental capacity. Sometimes you may have a fall, you hurt your head, no mental capacity. Okay, so in the case of people who, let's say, bedridden, cannot talk, or dementia, what do? We will go down. First, of course, we take instruction, and then during the time of signing, my secretary will come with me, and she will videotape. So I will communicate with this person, ask a few questions. Either you nod your head if it's yes, shake your head if it's no, or in 3 weeks ago, they used a board with all the alphabets and all the numbers, and she can actually point to it. So my secretary will videotape that I have communicated, this person understands, has got mental capacity, and nobody is forcing her. Okay. So sometimes you have parents who may not want to do a will, but the children are around pushing her to do it. So we have to ensure that they are doing it voluntarily. There's no coercion there. Okay. So to be safe, we videotape. If any time we are challenged, we will produce a videotape that I have established this person has capacity. Voluntary, so no coercion, no compulsion. Clear instructions. So we have to establish that whatever you want is very clear. So we will actually run through the will again. Auntie, is this what you want? You know, you're giving to these persons, they are your children, etc., etc. So we are very clear with them before we actually let them sign the will. Sign before 2 witnesses. So there must be 2 witnesses that sign, and these 2 witnesses, bear in mind, they must be adult, understand what they are witnessing to. They cannot be a beneficiary or even the spouse of a beneficiary. If you give your children something and you ask them to sign as a witness, and they are adult, they are good as witnesses, but they are not good as beneficiary. Their share will be gone. Okay. Make sure that even their spouse do not sign it. If the spouse sign it, again their share is gone, but they are still good as a witness. All right. These days, again with social media and all that, many of you would think that it's fine, you can do your own will. You actually can. After you have listened to me, you can go home, draft your own will, get 2 persons to sign for you, make sure they are adult, they are not beneficiaries, they are not spousal beneficiaries. Sign in front of you and you sign in front of them. It's a good will. Okay? However, there are drawbacks. Why is it that you use a lawyer? Is because if it is actually challenged, some questions that you can challenge, if it is just a non-lawyer signing your will, or a lawyer signing your will, there's a difference. Questions like, has this person got mental capacity? Has this person done it voluntarily? Are the instructions clear? These questions go away. The court will not look at it once it sees that there's a lawyer signing it, because we have to establish that these things are all there before we get a person to sign. Whereas if it's another lay person who witnessed the will, somebody can challenge and say, you know, my mom doesn't know what she was signing, it was not explained to her, etc., etc. And while you can say that I did explain, there's a question mark in the court's mind, did you actually explain? You know, do you have somebody else to vouch for you? But when the court sees there's a lawyer signing it, some questions just go away, okay? Because it's our job to make sure that things are done like this before we allow you to sign. Okay, let's go on. Because you all go traveling quite often nowadays, husband and wife go traveling together. Plane crash. What happens to your property and to your wishes? Okay, so that now becomes a question that people ask me. And we have got this rule that is called commorantis rule. Commorantis rule is a Latin word that just means those who die together. Okay, so the law has already explored all these questions that will come up. So what happens when two persons die together? Each of you has got a will, all right? Husband made a will, wife makes a will. Then whose will prevail over the other one? So this rule will tell you the one who is older is presumed to have passed on first. So if a husband and a wife each has got separate will, husband gives to probably his own siblings, etc. Wife gives to her own siblings, etc. And it is quite common, when you do a will, you will say that all that I have, I give to my spouse. If my spouse predeceased me, or if my spouse does not survive me, then I give two. Then let's say you put all your siblings, okay? And your husband's side do the same. And then you all go traveling together. Book the same flight crash. And everybody's pronounced it. So the law will presume that the older passes on before the younger. Just a split second, okay? So therefore, the husband passes on first. Under the husband's will, all that I have goes to my wife. If my wife does not survive me, then go to my siblings. So in this case, all the husband's property move over to the wife. And then the wife will says, all that I have, if my husband does not survive me, it goes to my siblings. So therefore now, the siblings on the wife's side takes everything. Siblings on the husband's side take nothing. Okay? So remember this rule.
Brutal.
Okay, so remember all these rules when you do your will and when you travel together, yeah? If you're a royal family, of course they will never allow husband and wife to travel together, but you're not royal, so you book the same flight. And always budget flight, 2 persons cheaper than one, right? So you book 2 tickets together. So while you have got advantages, remember there are disadvantages. Okay? So that is all I think that I have for will writing. Now I can take your questions. Do you have any questions first before I just... Any questions? Yes.
The witnesses got to be 2 persons.
Yes.
Got to be 2 persons standing in front of you.
Not in front of me, in front of the testator. So the person who does the will sign, but when he or she is signing, the 2 witnesses must be there watching her sign. And after that, she must watch the 2 witnesses sign. Okay? So that's called in the presence of that person, you must sign. The witnesses need not know what you have written inside your will. All that they need to know is that this is a will, and I want you to watch me sign my signature.
That's they don't have to sign the paper.
The witnesses must also sign.
The witnesses will sign.
Yes. At the end of it, the testator sign, the witnesses also sign.
But they don't need to know what you have.
They don't need to know what is inside. And I tell you, that is important. Number 2, you keep the will that you have signed to yourself. Why? Because today you may feel that my children are so nice to me, you know, I've got to give them everything. And it happens, okay? I've got somebody who has done a will like 4 times. Keep revising it. My children doesn't come back, he doesn't give me any money. Take him out, okay. So you change your will. If you have disclosed what you have to your children, and then you change your will, after you pass on, the child looks at it, I get nothing. You know, there'll be a lot of unhappiness. So don't do that. Whatever you think is the situation today, most people who do will, they come and they express their wishes as if they're going to pass on very soon. And I tell them that no, from my experience you can do a will. 20 years later you're still around. So, and over the years you will change your mind. Okay, so therefore keep the will to yourself. Whatever you have decided, keep it to yourself. Don't let anybody know. And then you have the liberty, the freedom to just change your will. Okay, as things change. Yeah.
Someone asked whether you can share the slides, whether the slides will be shared. I'm just wondering.
Yeah, I suppose I can. Yeah, I suppose I can.
Can
You remind me.
give me the copies and then
Sure.
I'll
Okay.
Can you clarify how many copies the will and what's the original copy?
Okay.
Where should you keep it?
Okay. There's only one original. Even if you make copies, if you do your will with us, we actually keep a copy. But I can tell you, the copy is not good. The court wants to see the original. Why? Because like I said, you keep the will with you. Anytime if you're not happy with the will, you just tear it up, throw it away. And that's the end of it. So therefore, the court always wants to see the original. Without the original, there's a presumption this person doesn't want his will, he has cancelled it off. Yeah. So always keep the original with you. And you need to only let your executor know where to find your will. And most important, don't keep it in the safe deposit box where only you hold the key. Okay? Not that we cannot access, but it takes another 1 month in order we can open that box to get it. We write to the bank has to prove that this person has passed on, show death certificate, etc. It's a long process. And the more you get your lawyer to work, the more you pay. So don't keep it in a safe deposit box, keep it in a drawer somewhere. Let your executor know where to find your will if you pass on. Okay. Yes?
What if the executor, right, is on the same plane and he crash?
Okay, so what we will call, you have got a will without an executor. Yeah. So what happens? Then we will say, show us the will. Supposing you can show us the will. We'll see who are the beneficiaries. And then we'll let the beneficiaries know, these are the beneficiaries. Among you all, pick one of you to become the executor. You can have one, you can have two, you know. But the more executors you have, it can be more disadvantageous because they will then quarrel. Then you find that every time you go back to the court to get an order, not worth it. Pick a person that you trust, and just let this person administer it. Okay. Alec, you want to ask something?
What happened to you? Two questions. One is, some lawyer registered with the
Wills registry.
Something,
Yeah.
So how do you tear that one? Is that
You
considered
don't
original?
need to. They won't ask for your original. You will just register with them as a copy so that people can check whether or not you have made a
So what
will.
you kept is still the original?
You still keep the original. And many times we tell people, it's just not worth it. You pay some money, you register with them. You know, it doesn't serve any purpose. The court still wants to see the original.
Second question, what happened to you? Whole family traveling together? Following
Whole family, okay. Well, okay. So, let's say the whole family travel together, everybody passes on, and your will only has got family members, nobody else. Right? So therefore, we will say this person now has got no will. No will, your properties will be administered according to the law, like this case. And then we will kind of find out who actually would benefit under these rules. We would contact them and ask them again, pick out somebody who wants to do now what we call the administration of your estate. So when you have a will, that person is called an executor. When you've got no will, the person appointed is called an administrator. So letters of administration is given to that person.
Assuming you are divorced, then you travel with the kid from the first wife. then if the plane goes off, the all goes to the kid and then goes to the first wife.
Wow.
Okay. Simple answer. When a person is divorced, that person is no longer considered a legal spouse. So the person is out of the question. Yeah.
But then the children,
Okay. The children will still be your children. So long as they are your blood children, they will still be your children. And sometimes you may think that my stepchildren are also my children. Under the law, if you don't have a will, they are not. It's only bloodline. Okay? So, let's say you remarry and your spouse has got children of their own. And of course you look after them, etc. They take you as a dad, whatever. It's great. They are your children. But if you do not make a will, they are not considered your children for the purpose of your estate. Only your own blood children will be. That's the reason why some probably more savvy ones, or if you ask us, we will tell you, adopt those children. Why do people need to adopt their stepchildren when they are so close to them? Is because once you adopt them, they become your legal children and they can have your estate. Okay? The rules that I tell you when you don't have a will may seem just very simple, you know, but I tell you a real life situation. I've got clients, actually the whole family came to me, the mother, the son, later on the daughter. The parents divorced, and it's like 20 years you don't see the father at all. So the daughter is close to the mother, and the daughter, in her life there is no father. Okay, she would not even think that there's a father. And then she passes on without a will, and she is not married. So, no spouse, no children, who gets her estate? Parents. So the mother came and said, can you do the court thing for me? Because my daughter passed on. So we have to do it. And one of the questions we have to record in the application is, who are the beneficiaries? So we put down there the parents. And the mother was so furious. How can this father benefit when he's not in the life for the last 20 years? But that's the law. So the daughter also would not have realized that there is a father that is not in her life, but if she passes on without a will, the father gets half her estate. Both of you may be divorced, but both of you are still the parents of that child. Okay, so we go back, think carefully, okay, whether or not you should make a will. If you don't want your father to be in, you have to make a will. Right? So, okay, so, yeah. Yes, Wendy.
I wanted to ask, is it necessary to do will for the HDB?
Yes. The HDB, most of us would just write it off, nothing. These days, HDB is $1 million now. So do a will, yes. But you cannot pass on your HDB to your children if they already have HDB of their own. You can still will it to them, but HDB will tell you to sell it. Sell it, divide the money. Yeah. And then also, hang on, also, some of you may have property, and then you will it to your children. Your children probably are young at that time, you will it to them. You know, they got a share in it. Maybe 10%, you think it's okay, give them 10%. So this poor child only got 10%. You pass it on. Then the child wants to buy HDB flat. The question is, do you ever own a property? Yes. 10% is still yes. So sometimes you think you're doing them a favor, actually you're doing them a disfavor. They cannot get HDB now, they cannot hope to benefit from the HDB in the years to come. Okay, any other, somebody at the back, yes?
Okay, regarding this rule, right, if both spouses have wills, and they will with the assets to the children, if all die in a plane crash, including the children, right, so the law assumes the older die first, then goes to the children. and then the children's will, when it goes to the youngest child, all gone. So the surviving aunts and aunties, assuming no grandparents, the aunts and uncles will get it.
Yes.
Based on the law.
Yeah.
Which side of the aunts and uncles?
Yes. So that's a good question. If it comes to the aunts and the aunties, which side? Is it the father's side or is it the mother's side? So in this case, because they are children, all the fathers and mothers, aunts and aunties have got the chair. Yeah, I like.
If you will private property to a child HDB, then the child want to move to private property, must it sell the HDB?
Hang on, you say that again.
If you will a private property to a child
Okay.
who has a HDB,
Okay.
and the child want to move to private property, does it mean that he must sell the HDB?
Okay. So the question is, you will a private property to your child. Your child already has an HDB, and then when you pass on, number one, can this child keep the private property? Number two, if that child moves to the private property, must the child sell the HDB? All right. Now, first of all, there is this thing called a minimum occupation period. So, supposing your child has already lived there for some time, now you will a private property to the person. The child can inherit the private property, still keep his own HDB. If he wants to move over to private property, provided he has already lived there for the minimum occupation period, he can still keep the HDB, not an issue. Yes?
Pertaining to the question, if he inherits the private property, will he pay the ADSD of the private property?
For what? Oh, I see. Okay, okay. Good question. Very good question. These days we have this thing called ABSD, Additional Buyer Stamp Duty, and it's very expensive, very high. Your second property, you pay, if you're a Singaporean, you pay 25%. If you already own one and you buy a second one, 25%. Extra. You buy a third property, 30% more. Okay? So therefore, to own a second property, difficult. So, because you come to my talk, I give you some tips. Try and tell your parent, if you ever think about giving me something, okay? How about giving me a property? Because a property that it passes on under a will, no tax. Okay, no tax. So negotiate, all right, negotiate. How about give my brother all your cash, etc. Let me have your property. Any other question? Yes.
Let's say you have the last daughter staying with you.
Yeah. Yeah.
And then this last daughter cannot afford to buy BTO flat.
Okay.
Then can the sisters just the sisters ask her to leave the flat, ask her to leave the flat, and ask her to sell off the flat, and she don't know what to do there.
Okay. So the question is, there's a HDB flat.
Yeah.
A child is staying there.
Yeah.
A daughter is staying there.
Yeah. Youngest.
Youngest daughter. So let's say the owner is not the daughter.
No.
Okay, so the owner, probably the parents.
The mother.
The mother.
Yeah.
So the mother passes on. Can the sisters ask her to leave and sell the flat?
Yes.
Yes. Okay, so first question is, what is the wish of the mother? If the mother wants the daughter to carry on staying there,
Yeah.
the mother should write a will. Write a will to say that if this daughter still wants to stay in the flat, allow her to stay. However, the flat should be given to somebody, given to her or given to the other siblings, whatever. Because if you don't specify that the flat is going to be given to her, then the HDB will come and tell you you have to sell the flat.
let's say example, let's say the other 4 siblings
Yes.
don't want to care about the person who passed away and don't want to take care of a funeral, everything.
Yes.
Because she want the youngest to stay inside the house.
Yeah.
And is it right for the let's say example the first 3 daughters, because one is not very sound.
Okay. Okay, Auntie. I think this will take a bit of time for me to explain to you. Maybe later on I will meet you and then you can talk to me separately. Okay? So, yeah.
What about overseas property in our wills that we write? Stating the overseas property, how Singapore law and overseas law?
Okay. That's also a good question. Yes, people these days own overseas property. So you have overseas property. Now, assuming the will is made under Singapore law, okay, so therefore Singapore law takes precedent. So whatever you write down as the wish of your overseas property would still be valid. The only problem is that will have also to be sent overseas, where an overseas lawyer will help you to register it. We call it resealing. So one, the will is accepted in Singapore. The court gives what we call a probate, the sort of something like a letter that says this will is good, this is the executor appointed. And then you must take that will and the probate, send it overseas to be re-registered with the overseas courts. And then that overseas property can then be sold, whatever, and then, you know, to be done according to your wishes in Singapore, according to your will. Yeah. So what we normally do is that because the receiving process again takes time, what again we would encourage clients to do is do 2 wills. Do a will that governs all your property in Singapore. Do a second one that governs your property overseas. So once you pass on, the will that governs property in Singapore, give it to your Singapore lawyer. They can immediately do the administration. Then your will that governs the property overseas, send it over there, appoint a lawyer, they will do the same thing for you. So therefore, in situations like this, we actually write very specifically, this will governs my estate only in Singapore, you know, and then do a second will for your overseas properties. Yeah. Yeah, good questions. Anything else? Yes.
So what happens if we have a will and when we die, what are the costs involved to execute the will?
Okay. Well, apart from writing the will, of course, it depends on whether it's a very simple will that you have, you know, or that I have, I give you 1, 2, 3, 4, 5, 20% each or equally, whatever. That's what we call a very simple will. Or it's a more complicated one, where you have individual assets you like to have a certain way to deal with it. So that one, that's the writing cost. Okay. Besides the writing cost, when you bring a will to the court and get it, what we call certified in our language, you call it to obtain the grant of probate. Then it depends again. If your estate is below $3 million, the cost is much lower. If it's higher than $3 million, the cost is more. These are court fees. Okay, so it's a government way of taking back something. So if you do the administration below 3 million, less court fees. If it's more than that, more court fees. Generally, if you get a lawyer to do it for you for probate, generally it's like maybe 3,000 for the lawyer's fees. Anything from, let's say, 2,000, 3,000, and then court fees is another $600, below 3 million. Above 3 million, depending again on how wide the estate is. The court fees can go up to 1,500, 2,000, or things like that.
Sorry, I add on to this question because I hear like, you know, when someone passes on, even with the will, then they have to write to like individual bank to say, okay, this person has passed on, and each letter costs $X.
Yeah, yeah.
Is that what you
Yeah. This again, it's a lawyer that you know. So what we actually recommend is, again, because everything is digital, no records at all. So it will be good for the testator to write down in a list, what are the banks that you have? Most important, the bank and the bank account. And then with that, at least the lawyer doesn't need to write to like all the banks, but only the banks that you have, and ask them, tell us what is the last balance about the date of death, because you need to declare that to the court. And that kind of like the summary of that would represent the amount of your estate. Yes, your other question.
Pertaining to Wendy's question, getting the letter to the banks, shouldn't we get the grant of probate, and then we can, as an executor, if I get the grant of probate, I can just go to the bank without paying anything to get the deceased statements?
Okay. Number one, you cannot get a grant of probate unless you declare how much the person has got in terms of the estate.
So we have to do the schedule of assets.
Yeah. So therefore, to get the grant of probate, you must declare how much this person has got in the estate. In order to declare what you have in the estate, you must get the amount from the banks.
Wouldn't it be easiest that you have another names inside the bank, beside your name, like your daughter's name?
Yeah. So again, these days, because it's all digital, it's actually quite simple. If you have got joint accounts, and either one can operate the account, one person passes on, the other person can just draw everything and then close the account. Yeah. That's the easy way to get your hands on the money. The difficulty is if there are other beneficiaries and they say that that money is not yours, even though your name is joint. Yeah, so that money is not yours, that money has to be shared according to the rules. So yeah, you can have somebody for ease of administration of your account, but there can be other problems. So you must make very clear if you put somebody in, whether it is your money, for convenience you put a person in, or that is actually meant to be a joint account, and anything that is joint account, joint property, there is this rule that says survivor takes all. So therefore, if you join with somebody and it's meant to be an account that both of you have got equal shares, or rather each of you own the whole account, one person passes on, the other person takes everything. So when you buy a property in two names, you put a joint. If you pass on, the other person takes everything. Okay. These days you have more of these sort of cases coming up, where children would dispute that, no, my father puts in my elder sister's name, but actually it's not hers, and it's just for administration. So it's better that you make it very clear, right somewhere.
Can you wheel it inside there also?
You can will it inside, but that's not good enough. You can, in your will, say that this is not meant to be, but then the circumstances may contradict it. Okay, you may say that this is my property, then the joint owner can show that, no, actually I paid a lot for this property. It's not meant to be yours. You can say that, but circumstances may be different. Sorry. Wait,
I'll just let one last question, because we've got other things to go on. And I know now why lawyers earn so much money, because life is so complicated. but I want to kind of close it up. I don't want to just do one on wills, PA and advanced care planning. So can I take one last question? After that, I will open a desk and I'll charge $50 per question. No, but I think Kibla will answer the question, but give him some space and time. Okay? So maybe Paul. Okay. Sorry.
I want to know how about then in that case the shares, stocks and shares, and how is it? Let's say within the will that all our shares is to be distributed. Who will go about helping the lawyer to check it out, or?
No need. Your shares are part of your estate. Once the executor has been appointed, the executor will do it for you.
Oh.
They'll go to CDP and then tell CDP that this is the wishes in the will, and then the CDP will just transfer to whoever that is.
Or you have to sell it? Must they sell it?
No need. You can just transfer to the name of the person who is supposed to benefit from it.
Oh, okay.
So with Paul's last question, then I move on. Then later at lunchtime, we can still ask some more questions. Okay?
In Singapore, can you condition your granting of the beneficiary on certain things? Like say, I give to my kid only if he goes to church
every Sunday.
I like, can I borrow that phrase? Just joking, just joking.
You can. You can. You can. You can put in conditions. I will give to my child only when he turns 35 or something. You can. But remember this. The person who is doing it for you is your executor, your trusted relative, your trusted friend, and he's doing it for you for free. If you put a lot of responsibility on him and he has to police it all, it adds a lot of work to him. Okay? Sometimes the executors, when they see that it's so tedious, they actually would refuse to administer. Then you are stuck. They got no administrator, okay, or no executor. Devin, you look like you got a question.
Yeah, what is the usual cost to do a will with a lawyer?
Oh, that's spot on, man.
Well, that one, it really depends. Every lawyer charges differently. So, like I tell you, it is. There are two types. One is what a simple will. One is a more difficult will. Simple will, a few $100 you get it. Yeah. Okay, I think
maybe to close that because we do have other things.
Yeah.
So maybe, how long will it take to do the LPA?
Maybe 15 minutes.
Okay, maybe in 15 minutes take a break, then we come back with advanced care planning because I think we want to finish the thing with lunch. So that's where we go. Is that all right? Okay, yeah, thanks. Do the LPA now, then we take a break. Yeah,
okay.
Is it okay?
Now, okay, LPA, I'll just do it a bit quickly. LPA stands for Lasting Power of Attorney. Okay. Why do we need this is because these days, again, very different from the old times, if you have money, if you have a lot of assets, and you don't have capacity, many people like to look after you. Why? Because if they look after you, they also get their hands on the assets. So if they say that I bring this person for a holiday, we find first class, he also finds first class. Okay, so therefore, it's good that you decide who you like to look after you, hopefully genuinely loves you. Okay, so that person is called, you have to give that person a lasting power of attorney. When you have got your mental capacity, when you are sane, you can do what we call a power of attorney. That means you're busy, you don't want to go and handle certain affairs, you can ask somebody to do it for you. That person has a power of attorney. But once you lose your mental capacity, that power of attorney stops. That one is only as good as you. If you can do it, somebody else can do it for you. But if you cannot do it, whatever power of attorney you have given, that stops. So therefore, the gap between the time when you don't have capacity until you passes on, where your will takes over, your wishes can be done, that gap, somebody has to help you. And that person must have what we call a lasting power of attorney. Okay, so that's a new thing, a lasting power of attorney that only kicks in when you do not have capacity. And the doctor has to certify this person has got no capacity, then the LPA takes over. Then the person can administer for you. The person under the LPA can do two things. One is your personal affairs. Personal affairs means your welfare, your medical things like whether or not you want to do clinical trials and so on, that part of it. The second is your property and affairs. Again, it's the same thing with all your properties. Okay? Now, to do this is a bit complicated because these days everything is online. You have to do it yourself up to a certain stage before the lawyer takes over. Okay? And from my experience again, a lot of chaps just don't know what to do. So I'm going to guide you. Take out your phone. I will guide you through so you know roughly what it entails until the stage where it's like Donis, and then I stop there so that you have an idea. You have done it once, you don't feel so frightened, okay? Take out your phone. And I will guide you through it. Ready? Okay, first you go to your Chrome. Go to Chrome, open up your Chrome. So the last thing of power, how to apply. Go to Chrome, go to Google. type in LPA Form 1. Okay. Thanks to my son, he also puts there at the right, the margin, what you will see on your own phone. Okay. So look for LPA, type in LPA Form 1. Okay. When you do that, this will appear. You have this whole string of documents you can go in. Look for this one, Office of the Public Guardian Online. Again, if you have a phone, it's circled in red there to look for it. Look for Office of the Public Guardian Online. Got it? Okay, I move on. This page will appear on your phone. When you click into Office of Public Guardian, this page will appear. Now look for Apply Now. Oops, sorry. Look for Apply Now, which is again on your phone. Got it?
To log in.
Okay, so
Apply for an LPA?
yeah,
Is that it?
yeah. If you press that button, Apply Now, your SingPass will appear. So now you log in with your SingPass. Following so far? Okay, so all of you have logged in with your SingPass. So this will happen. Now this page will appear. Look for Apply for an LPA. Apply for an LPA, you click on that one. Okay, move on. Yes, you go into your SingPass. And then this one will appear. This page will appear. Then you press Apply for an LPA. I move on. Next. Now you have a few pages that explains a lot of things. So you just click at the bottom, move on, move on, move on. Let's begin. And then you just click the button next, 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 next. I think 5 pages or something. And then finally, start there. Start. So now you start. So this is the actual form that you will see, where you have to fill in your particulars. Okay. Once the form appears, it's quite easy. You just need to fill up all the details there. My son puts in his name because otherwise he cannot move on. So you have to fill in this, then it will move on. Alright, so I'm going to show you what happens. You put in your details, then it will move on. Then again, you fill in more details of your address, correspondence address, etc. You just fill in the blanks. Alright, when it comes to this stage. Then, okay, then next you will see a page that says, tell us who your donees are. So now you name your donees. The donees are the one who has got the power to act for you. You are called the donor in this form. The donees are the ones that you appoint. You can appoint 1, you can appoint 2, you can appoint 3, whatever. And then they will ask you whether you want replacement donees. So in case one of them, is not able to act, you can replace donees. Then they will ask you, okay, then they will ask you, do you want these donees to act for you for personal affairs, or is it property, or is it both? If you use form 1, this is the simplest form. You file it, no money. You use form 2, you got specific instructions, you file it, Office of the Public Guardian will charge you $200. Your lawyer will charge you more because form 2 is the one where the lawyer actually writes up for you differently. Form 1 is just very standard, you just go through it, put all the ticks, okay? So property and affairs, then they will ask you how you want your donors to make decisions. There are 2 questions here. One is if you got more than one donee, whether you want them to act for you jointly or severally. Joint means they both must make decisions together. Several means that each of them can make separate decisions for you if the other person is not around. Okay? And then when it comes to your personal welfare, that means your health thing and all that, they will ask you a question. Do you allow them to accept clinical trials? For example, you have medical care and it's the end of what the doctor can do for you. And doctor says, look, we can't do anything more for this person, but there is an experimental drug or some clinical trials. Would you like to put this person on it? Then do you want the donee to make the decision or no? So you answer those questions. Then again, this is the consent for clinical trials. And then they will also ask you a question like, if you have property, do you allow your donees to sell the property? Or do you want the donee to go to court for permission? Again, that's important. Like I said, when you have a lot of assets, a lot of people want to be your donee because they also get into your property. Okay? So here there's a safeguard. You answer the question whether or not they can do it. And then the other question is gifts. Do you allow your donee to give gifts? If you say yes, is there a limit? Okay, otherwise the donee will be giving a lot of things to his children and relatives or whatever. Yeah. So, okay, then after that would be okay, then you appoint your donees. Okay, you appoint your donees are the ones that you want to do it for you. They also do review. After you have done your review, you're happy with it, then you will have to notify your donees. So at this stage, you will tell your donees that I've already done it, it's in the system. You go into the system, pull it out and you sign. So your donees can be away overseas, whatever. When you do that, they will give you an SSN number. You tell your donee the one-time password number. They log in. Your form will pop up. They will sign. After they have signed, again the form goes back into the system. And then next is that, are you sure you want to notify your donees? Yes. So you notify them, they will have. Then finally book an appointment with the certifier. The certifier are either doctors or lawyers. So only the last stage, then you give me a call and said, I've done my LPA, my donees are already all signed. Can you now sign for us?
A doctor or lawyer?
Doctors or lawyers can be the certifier. So you come to our office, again the same thing. You give me an OTP, I log in, your form pops up. Why is it that we want a doctor or lawyer? Because we run through the whole form with you. Confirm every particular, explain to you what it means to do clinical trials, explain to you what it means to give gifts, etc. You're happy with it at the end, then we sign. Once we sign, we submit, it goes straight to the public guardian's office. And that's the end of it. Okay? So I run through this with you because it's very complicated. A lot of times I just don't know what to do, how do I navigate this whole thing. So I just thought, since you are here, run through it with you.
So the question, if it's doctor, any doctors or?
You have to ask the doctor, can you be the certifier?
Then we have to give a link to them or you will just...
You go down to the office, then they will ask you for an OTP. So when you click down there, you have an OTP that pops up on your phone. You give it to us, we put in OTP, your form will pop up in our computer. Okay, that's all I have, I think. Yep. That's it.
Give him a round of applause.
Yes. yes. Donee can also be the executor of your will. Yeah.
Okay.
What does it mean that we can handle property? The donee.
Well, property means your assets. Okay. The restriction here is only two things. One is that in terms of selling your property, do you allow the donee to just go into the sell, or must it get a court order? Number two, do you allow your donee to give gifts? If the answer is yes, do you want to place a limit? So if you put a no, that means he cannot give gifts at all. Once they activate your LPA, every year the donee has to give an account to the public guardian. So it's a bit tedious. Okay, so they will have to give an account. What has this person done with all your assets? And it's a good safeguard there. Yeah, Emily.
Does this override the will that you have written?
Like I said, up to the time when you have capacity, you can do power of attorney. When you've got no capacity, if you have a lasting power of attorney, it takes over. At the time of death, your will takes over.
So, Irene there has a question.
What happens if your donee dies before you?
Okay. If donee dies before you, number one, do you have a replacement donee?
Would it be on that list?
It's on that list. They ask you that question. If you don't have a replacement donee dies, you're still around, and you know the donee has passed on, you would firstly revoke your this one, then you do a fresh one. Yes, last question.
LPA compared to this will. So this person, if they stop the breathing, that means the will kick in.
Yes.
So this LPA only stop at the moment last breath.
Yes. Okay, I hope it has been helpful.
Thank you so much.
For the young people here, I just give you one.
Yeah,
one
please.
Tip,
Yeah.
okay? Just one tip. Since you attend my lesson, I give you one tip. Young people always like to say, "How can I get rich?" And I always joke with them, there are only 3 ways to get rich. One, you buy Toto. My secretary has been buying Toto for 20 years, never. 2, you got to rob a bank. When you rob a bank, you go to prison. Number 3 is the easiest. Be very nice to your parents. Make sure you're always in their good books. When they pass on, you become a millionaire.
It's very nice to me.
Okay, so that is it. And also for those of you who are here and you have parents that are past 70, in my experience, the very elderly ones, they are very traditional. When they make will, between the boys and the girls, who do you think get a bigger share? Boys. So now today you attend my talk, you will go back to the rule. The rule says, if a person's got no will, the siblings get equal shares. So if you're a boy, you go home, you encourage your parent to do will. If you're a girl, every time your parents want to do will, you switch the subject. Okay, that's how I got.
I'm a son, so I should go talk to my parents now, right? But thank you so much. I thought I'd give you a 3-minute toilet break. Then I invite the nurses to do the parts when you go into the hospital, and that the doctors know what to do. This is where they can advise you besides the will and the LPA. I think that's equally important. So can I give you...
Hello, good morning. My name is Samuel. This is Rachel, my wife. Thank you, Uncle Kim Lark, for that great talk. Yeah, very interesting to know about wills and LPA. Now we'll be talking about advanced care planning, and how does that tie in with everything else that we have been said earlier. Yeah, Rachel will take over.
He'll come back later again. So advanced care planning, as we all know, is ACP for short. Next slide, sorry. Hey, who do I tell you? Huh? Okay, yes. So if you haven't seen, you may have seen us running around chasing after these three little kids, right? So both of us are from KPC, and Sam is working as an advanced practice nurse in Tan Tock Seng, and I'm working as a part-time nurse in National Heart Centre. Yeah. So before we begin, we'll just briefly touch on this point. So what is advanced care planning all about? Why it matters? And earlier on, we learned a lot about will and LPA, right? So we also touched a bit about advanced care planning versus LPA versus your advanced medical directive. What are the differences? Okay, and benefits of doing an ACP for yourself. And then lastly, we will also, if we have time, we will go through the My ACP portal. So the My ACP portal is an initiative that the government rolled out earlier this year. So they encourage all citizens to just do your own ACP online. Pretty much you can do it on your own and anywhere lah. So we will go through it if time allows. Okay, yes, so advanced care planning, basically it is an ongoing process of planning and preparing for your own healthcare decisions. And this involves a few conversations, okay, about your own beliefs, your own values, what are important to you, and how do we align your healthcare preferences to that lah. So your preferences will then be shared with your loved ones, your family, and also your healthcare team. Next. So why it matters, right? It is vital, okay, to actually do up your advanced care planning while you have the mental capacity and you're able to communicate and speak for yourself. That way you are able to tell your loved ones, what kind of care you would prefer and how does that align with your values. So it gives you a peace of mind for yourself, knowing that, having this document done up, your voice will be heard. Yeah, in the event that you are no longer able to speak for yourself. And your loved ones, they are also more assured, okay, because they know that they are making a decision based on your prior expressed wishes. So it reduces any uncertainty, it minimizes potential conflict between family members, okay, and also guilt. And your healthcare team, they will be guided by whatever that you have indicated before, and they will be able to act in your best interest lah. Okay, so advanced care planning versus LPA versus AMD, what is the difference? After this slide, we have a slide with a very big table, lots of information, so it might be a bit difficult to digest all of that at one go. So if you can't retain any of that, I thought to put just a very simple summary here. In short, right, advanced care planning is all about your values and your healthcare preferences, okay? LPA is, earlier on we talked about someone that you appoint legally, right, to decide for you about property, your welfare matters, and hopefully genuinely loves you lah. And then advanced medical directive, it is a legal document that states your choice to decline life-sustaining treatment. So a little bit more about that in the next slide. Okay, so this is the very overwhelming table that I was talking about, right? So it has the what, who, when, coverage, who does it, and the cost for the three things. But I thought I would just highlight a few important stuff. So advanced care planning that you do up, right, it is a non-legal document. So non-legally binding, it simply serves as a guide. Okay, you can change it, especially when, let's say, your health changes or life circumstances changes, you can change it, okay? And yeah, LPA is what we already went through, so I think maybe I don't need to touch on that lah. Oh, okay, maybe an important thing to note is that the how do I pronounce, the DANI, is it? The one that you legally appoint? Doni, sorry, the Doni. He is empowered to make decisions on wealth, property and welfare matters, right? They are also able to make basic healthcare decisions on your behalf. So this will include things like where to live, who to live with, okay, when you're unable to make such decisions. However, they cannot make decisions on life-sustaining treatment or any treatment that will help prevent serious deterioration of your health, okay? Advanced medical directive, I'm not sure if you all have heard about this before. So it is a legal document that is allows you to state that you do not want extraordinary life-sustaining treatment to prolong your life. So this will include measures like CPR, putting in a breathing tube, feeding tube, this kind of thing. Okay. However, it is a little bit difficult to carry out. So under the when rule, right? Okay, it only takes effect when you are certified to be terminally ill and that death is imminent lah. And this has to be unanimously certified by 3 doctors. So one will be the hospital doctor that's taking care of you, and 2 others have to be specialists. So until these 3 people all agree that yes, this person is terminally ill, death is imminent, then after that, they have to go and check with the Registrar of Advanced Medical Directive on whether or not you have ever made an AMD. Okay, so they are not allowed to ask you, let's say when the person arrives at the hospital, the doctor is not allowed to ask whether you have made an AMD before or not, due to potential ethical issues lah. So based on our own work experiences, it's not very practical in real world settings. So in fact, very few AMDs have been effected over the last 2 decades. Okay, next. So all in all, okay, benefits of doing an AMD, it will help you, it will help your loved ones and the healthcare team that is taking care of you lah. It takes a compassionate approach that will honor you as a whole person, not just your disease or your condition. So doing up your ACP, it gives you some probing questions that help you to reflect on what is important to you. Okay, helps you to communicate your wishes clearly, and it will also help to strengthen trust and understanding within your family members. So at this point, I would actually like to share a story about a patient that I encountered during my course of work. So let's call her Madam C. So Madam C was an 82-year-old lady living with heart and kidney disease. She has 2 children, a son and a daughter. So when I first met her in the hospital and brought up the topic of advanced care planning, she shared that she hadn't given it much thought lah. She said she preferred not to dwell on such matters, as she thought that thinking about the future would not change what's meant to happen. So when I asked her, what might happen if she has to live without abilities that she values, such as, being able to eat on your own, being able to shower, being able to move around independently, then she said she hadn't really considered what life would be like if she lost them. And the only thing she mentioned was that if she were to pass on, she hoped that it would be peacefully in the comfort of her home. So she wasn't also very forthcoming about the relationship that she had with her son and her daughter. So it was very difficult to encourage her to go home and have such conversations with them lah. So less than 2 months later, she was readmitted with a heart attack and she was unconscious. And doctors have explained to her children that doing an angioplasty, like a stent or a ballooning, would carry a high risk given her heart and kidney condition. So her son felt that his mother should receive comfort care, and be spared from any more invasive treatment and unnecessary suffering. Her daughter, however, on the other hand, believed that her mother had always been a fighter, and so she would want every possible intervention to be done for her. So they struggled to come to an agreement, and unfortunately, before a decision could be made, her condition deteriorated and she passed away in the hospital. So her daughter was left with very deep guilt. Okay, she felt that she had not fought hard enough for her mother, and she blamed her brother for giving up on her mum. So in the end, Madam C also never had the chance to express her wishes, and including her hope to spend her final moments at home. So this is a very sad story, but also a very real one, and one that reminds us why having these conversations early is very, very important. Yeah. So now I will hand the time to Sam.
Maybe we pause here for a while. If you all have any questions, you all can ask and we'll try our best to answer it. Yeah.
Is there an overlap between the ACP and the AMD, or is it completely separate?
There is a life. You do make some preferences about what happens at for your care at the end of life, but so one is legally binding, which is the AMD, but it's so confidential that even your medical team don't know about it and cannot know about it. And it's very hard to get it in practice. Yeah, so you can make an AMD, but your medical team knows nothing about it. Until the time when, yeah?
I don't think so, because I did my AMD and the
Yeah.
doctor told me that it's in the registrar.
It is in the registrar, but It's in the registrar, but we cannot access this registrar until you are
terminally
ill. Then we go in, we ask when you're terminally ill, certified by all those three, then we, okay, I don't know whether you have AMD, we go to ask the registrar, does this person have an AMD? If this person has an AMD, then we will work on it. So it is in the registrar.
That means your doctors have no right to go in?
Yeah, we cannot anyhow go in and check whether a person has an AMD or not. Yeah, it has ethical...
I met that two conditions.
Yes, until you're terminally ill, which sometimes can happen very suddenly, and there's no time to ask this question, like this person have an AMD or not. Maybe you say like, I don't want to have any resuscitation, I don't want CPR, I don't want to have defibrillator, I don't want to get shocked, I don't want to put a breathing tube, but we don't know. We don't know until by the neck suddenly collapse. There's no time to get these three people to come and certify you, and then there's no time to go into the registrar and ask whether you have AMD. We have to just, because we haven't state your preferences, we straight away save you first. Yeah.
So
but there is, sorry.
It's not as like, you know, in the movies it says DNR, do not resuscitate. It's not as straightforward as that.
So that is a preference which is from the ACP, that you made a preference, and that is known, is stated there, and once you go in, we can see that who has ACP done, who has not an ACP done.
Okay.
And if you stated your preferences, therefore no or not for resuscitation, we know. And we know that you have stated your preferences. This guy doesn't want CPR, and so that is your preference. But from the doctors and medical point of view, we also have our judgment. Let's say you are very young. You're very young, maybe you're like 40, 50 years old. You're completely healthy, but you have put a chance that you don't want to get resuscitated if anything happens. But from the medical point of view, we feel that you have a good chance to survive and recover. If the time allows, we will have that conversation again with you, with your family, and say, maybe this is not in your best interest. Maybe you want to reconsider this, do not resuscitate. Or in the opposite could happen also. Let's say you put, I want everything. You could, like a lot of diseases, or you're very frail. I want active, I want to go to ICU, I want to get the breathing tube down, I want CPR, I want all the drugs that you want, I want all the machines to make me survive. But the medical team say, this could lead in more suffering and it could be futile. Then maybe if time permits, we also will have that conversation with you and say, maybe you might want to rethink this preference. Yeah.
If it's AMD done, can it be revoked by the children?
It's legally binding.
So the kids
cannot. They need to.
You need to
execute it. Yeah. But it's very confidential. Yeah.
Yeah. Because you mentioned ACP is a non-legal document. What happens if your family member has a different opinion of your preference?
So yeah, maybe. Okay.
So that's why it is important to do up this document now and have these conversations with your family members. So in the unfortunate event, if they cannot see eye to eye, okay, it is still your body, right? You will still document what is your preferences, and the doctors will follow that and guide them.
But once you are mentally incapacitated, right, you cannot argue for the child. Your family member has a different.
But this document is in place, so the doctors will be.
Yeah, it's not legal.
Yes.
Not legal in the sense that it doesn't have to follow it by word by letter like a will.
So the doctors don't have to follow it, neither do they have to follow whatever that the next of kin says. So all things considered, plus the patient's conditions, what are some, age and stuff like that. The doctor is the final decision maker. Yeah. So to add on to the question that you were asking, right? AMD is a legal document that states you just don't want life-sustaining treatment. ACP is a little bit more broader coverage. Okay, so we will talk about things. You will actually have to think about whether you want to continue life-sustaining treatment. But okay, it talks about whether you want any life-sustaining treatment, or whether at the other end of the spectrum you don't want. Okay, and you really just want to be comfortable. Okay, and to go naturally without any extraordinary measures. Then there's also the in-between, that you will want to continue life-sustaining treatment until the following outcome happen. For example, you know, maybe you talk about like length of time, like if after 2 weeks and the doctors see that there is no progress, no improvement, I would want to stop. Yeah. Okay. Or there is burden on the family. Yeah. This is the place that you can state all of this down. Yeah. Which has you don't really see. You won't see that in the AMD. Yeah.
Yeah, and then usually we encourage like family members, spokespersons to come and do the advanced care planning together. So at least there are more people who are be on the same page. Yeah. Okay. Any other questions? Okay. If not, we will go on to the components of the MyACP. This one is the online platform lah. And before you do anything, I think this one is meant for people who are generally healthy lah. So the serious illnesses are excluded from this one. So there is a separate kind of ACP, or what we call a preference of care lah. That one with or disease specific ACP, that one will be done for those people. So let's say that if you have cancer, heart failure, end stage kidney disease, dementia, chronic neurological disease, chronic obstructive lung disease, or other end stage lung diseases, or severe liver disease, this one you need to contact your healthcare team or a trained certified ACP coordinator lah, to do the ACP. So if you are generally healthy, you can do the MyACP online lah. Okay, so now we'll briefly talk about these different components before we go into it in a short while. Yeah, so firstly we have the personal details. This one can be retrieved from the SingPass lah. This one happens quite fast. Okay, then after that we also have your personal health information. So this includes your whether you have any underlying chronic diseases, or does your family have any underlying chronic diseases. It also includes here your experiences with healthcare lah. And let's say you experience a friend or relative who have gone through certain healthcare experiences, and then what you learn from it. There's just one portion there for you, they can fill up also. Okay, next portion we'll be talking about lifestyle. So this will be things that you enjoy, and also your sources of support lah, whether it be friends or relatives. Yep. Next section we'll talk about your fears and worries. So do you like scared of pain, or do you scared that you lose all mobility and become dependent? So these are some of the options that you have there also. And yeah, so for all of these options, most of these components, they have a drop down box for you to tick. Or then if those don't apply to you, there's a portion also at the back that you can put in your own wording lah. Okay, so these are all your preferences, and this is the portion that we talked about just now. Will be the goals of medical care lah. So this one we will go through. We will show you later, and then if you have any more questions on this part, you can ask also lah. Okay, and then following that we have care preferences. So this one also you have different options for you to choose, and lastly there will be a nomination of your healthcare spokesperson lah. And if you have any additional requests, if any lah. So the nomination of your healthcare spokesperson is encouraged to be the same as your LPA lah. So the person who decides your estate, your personal welfare, also gets to be the main spokesperson for carrying out your ACP lah, or speaking up for you lah when you are unable to do so. Alright. So these are the components. So next time go. So if you are willing, you can use this QR code to go into the my. Or if you're ready to do it now, you can do it. But if you're not ready, it's fine. Also, you can think about it. Have a chat with your family members. And there's more information on advanced care planning on the QR code on the left. Right. Oh, your right, my left.
Your left.
Oh no, oh your right. Sorry. Yeah. So that's the ACP booklet that has briefly what we talked about previously. They have all the different components for you to answer all the questions, and then they will help you to think about the different things that is covered in the ACP lah. And then when you're ready, then you could either go to MyACP or you could contact a certified ACP coordinator to do it. Okay.
This QR code has been deactivated.
Oh no.
Okay.
Okay. So which one was deactivated? This one. Oh.
Both, okay.
Oh man. No, you just type in my ACP on your Google. You will get there.
My ACP.
Also can.
Yeah.
We have some hard copy
Yeah.
booklets also if you prefer.
So,
but
yeah.
we only have about 20 copies. Okay.
So the hard copy booklets are the hard copy of the ACP booklet. If you want ACP booklet soft copy, I will get it to you. Yeah, so this QR code is not working. Sorry.
You can go to online.
Yeah. Okay. So any who wants? So Rachel will be going around to give out the booklets. For those who are anyone doing the MyICP now? Okay. So if you're interested to do the MyICP, so this will be the personal particulars page lah. Okay. So that one you can use the SingPass. It will happen quite fast to retrieve it.
Rachel?
Okay, so once that's done, this is your personal health. So you can just state whether you have any concerns with your health, so whether your family or you yourself have any health conditions, yes or no. But of course, excluding all those serious illnesses that we mentioned earlier. Alright. I think before you go in, they will ask you to state that you don't have also. Yeah, this is the health experience. I think it will take some time. That if you have, then there's a drop down box for you to put in like what you took away from that. Maybe that can be done. Need some reflection. Need some time to think about it. And yeah.
So you can save as draft. If you're not ready to talk. Click a response.
Yeah. So this is Rachel's one. She put in. Yeah. Okay. Maybe it takes some time for you to do that if you want. Okay. The next portion will be the things that you enjoy. So there's a drop down box of all the options. You can click, or then see which one applies to you. If not, there's a other option at the bottom for you to put in your own words. And then next will be your sources of support. Alright, it's also under lifestyle. This one you can click also, and then there's also a drop down box for others. And then they also will ask you how do they help you, in what way. Yeah. The next portion will be the fears and worries. This one also they have the different options for you to click. Yeah. So like medical expenses, pain, discomfort, or impact on loved ones. Okay. And then this is the portion which will be the portion with the most questions. So this was the first one that we discussed, the goals of medical care. So this portion you have two options. First option will be that of comfort focused care. That means if let's say you don't want comfort focused care, means you don't want any life prolonging measures such as chest compressions or CPR. You don't want to get shocked if your heart goes into a dangerous arrhythmia or dangerous heart rhythm. You don't want to get shocked. You don't want to put in a breathing tube. You don't want to go to the ICU, and you don't want and you don't want the life-sustaining drugs, machines, all that. So, but this is the scenario above is the one where you have to think about before you make this decision. So this would be that. This scenario will be that imagine that if you have an injury or an illness, that the doctors believe that further aggressive treatment will not reverse the medical condition, and that you have a low chance of recovering the ability to make decisions for yourself. So you won't know who you are, and you won't know who you are with, and you don't know where you are. So that is a scenario to think about. In this scenario, in this context, what would you want? Yeah. You want us to focus on comfort, so no life-sustaining measures, but a lot will be done to make you comfortable. So there'll be painkillers, there'll be sedatives. They'll still give you oxygen, of course not through a breathing tube, but as much as they can give you through a mask, they'll still do that. They'll, basically try to minimize whatever symptoms that you have, like nausea, vomiting, constipation, everything, just to keep you comfortable. So still a lot of things will be done, just not the life-sustaining measures. So it's not like, I take up all kinds of, all medical treatment, I just leave you to die. No. So we don't prolong your life, we don't prolong the life, or in some cases we are actually prolonging death and leading to more suffering. So we focus more on comfort. So that's the first measure. The second option would be what we call full active. So do everything. Do everything to keep me alive. I want all the drugs, all the machines, all the breathing tubes, whatever it takes to keep me alive. So this is the second option. Alright? Yeah. So, and then you have to state a reason why you choose to do so. So at least we can see what is your rationale and your thought process behind it. Alright? So as we mentioned before, if this is your preference that you have stated, all things come together, doctors also have make the call and to see whether this is in your best interest or not. Alright? So if one of those two scenarios that I explained earlier, then we will have that conversation again with you and with your family members to see whether you would want to reconsider. Yeah. Any questions at this point in time?
Is there a third option, or is it just these?
So there is. I think once you click the all life-sustaining treatment, there's another box that you can fill that you want this treatment until when like some condition. Maybe like try maybe different criteria like time or like based on doctor's decision medically futile, or maybe my medical bill exceed like 1 million, I don't know.
Or like my ability to think, talk, eat or walk is compromised. Any of this, that is particularly important to you, then you will write it down.
Yeah, you can think about it and then write down. So yeah. Okay. Okay. So this portion will be on the care preferences, and then there's what's important to you in your treatment. Okay, so there are different options for you to tick also, and there's also an option for you to put in your own. Alright, and lastly would be the one on next slide, I think. The nominated healthcare spokesperson. So this should be encouraged to be same. And if you have done an LPA, put the same person. Okay, so then the same person will be in charge of almost everything already. Yeah. Okay, so that's it. If you have any questions, yeah.
Compared to AMD and ACP.
Yeah.
Once you sign already, can be revised later?
The ACP?
Yeah.
Can change. Limited.
So like you see, when I did up my ACP just now, right, I clicked on I want all life-sustaining treatments because I feel like at this point in time, I need to live for my kids. So even if I only got 1% chance, right, I will do everything. I want the whole cocktail of medications, right? I want it all, right? So that's me now. But life circumstances change, and when there are major life events, or your health status changes, you can revise it accordingly whenever.
Also the AMP.
No, AMD is a legal document, so if you want to revoke it, then that's another thing altogether.
I think you have to go through another process.
Go through legal process.
Yeah, go through the legal process to do it. Yeah.
So for this ACP, once you submit, that means it's considered your wish already.
Yeah.
You don't need to have anybody to certify it or to verify it.
For the general one? No.
For this general one,
no need.
But the person, because there's one more person that you are pointing to,
yeah.
and that person need to agree, right?
Yes, the person needs to agree.
So at least the person needs to know.
Yeah, the healthcare nominated spokesperson should know what's going on.
This document will be routed to the.
Yeah, it will be routed.
The person that you nominate, yeah, they will also receive a notification, like just now when you nominate someone to be your LPA, right? Same way lah. They will receive a notification, then they need to accept. Yeah.
And then that's it.
Yes.
Yeah.
The complete process.
Yes.
It will be in sort of
in the registry lah.
Yeah, in your health records lah.
But this is general, General, yes.
Oh, so there's a different one.
If you have you have like those conditions, serious illness that we have talked about, there's a specific one that we can do for those conditions lah.
Yeah. Then that you will need somebody.
Yeah, now you need somebody to do it with you lah. So it's not so simple as kicking the boxes and putting down the thing. That one has a bit more nuances that they will talk about lah, relating to the disease itself. Yeah.
Won't be a non-Singapore resident.
Oh, this one.
We don't know.
I'm not sure.
We leave you on the streets. No, I can't.
Yeah, no, I don't know. Yeah.
In a hospital setting,
Do
an ACP, who do you approach?
You just tell the nurses or your healthcare team. They have ACP coordinators in the hospital that can come and do it for you while you're in the hospital itself, or maybe they make a follow-up appointment to come back and do outside in outpatient for you. So they have people who will do it. But for those, I think they do charge about $30-something. Yeah, they do charge for one ACP. And that one must be by cash, cannot MediSave. That's why not a lot of people like to do. You tell them you need to pay out of pocket, they don't do already. Yeah. Anyone have any more questions? Yeah, so if no questions, I hope this session was helpful for you to differentiate out ACP, LPA, and AMG, and then see and consider having this conversation with your family, and and maybe you can try your hand at putting up a ACP yourself. Yep. Thank you.
Thank you.